Tonight we have with us Amy Demma, who's a prominent New York lawyer in the area of assisted reproduction, surrogacy, knows the courts in New York, and I will tell you a little bit about her. So she provides legal counsel to parents, egg donors, embryo donors, sperm donors, clinical practitioners, surrogacy agencies, egg donation agencies, and all intending to pursue surrogacy in New York under current law in New York, and also under the new Child Parent Security Act, which I'll let Amy tell you about her efforts to have this law passed over the years. And I think that would be a good bit of history for you to hear. A little bit about me. I told you my name. I'm attorney Vicky Ferrara. I am a lawyer for over 30 years. I'm licensed in Connecticut and New York. I practice in the area of assisted reproduction as well. And I own and I am the founder of the surrogacy agency known as Worldwide Surrogacy, which has been in existence for 15 years. And we help many people throughout the world to have their children through gestational surrogacy. And I have an office in Connecticut and also in New York. Amy, why don't you tell us a little bit more about you and your efforts in getting this law passed in New York?
Yep. Thank you so much, Vicki, for having me, and thanks for all the attendees for making time for this discussion tonight. It's my pleasure to be with all of you. So I am, like Vicki, an assisted reproductive technology attorney. I have been a New York licensed attorney for 30 years. I've been in this field of assisted family building for 18. Interestingly enough, started out working for Resolve, the National Infertility Association, on a mandate for federal legislation for insurance coverage. What's really interesting about that fact is that was 18 years ago, and we still do not have a federal mandate for insurance coverage for those going through assisted family building. But that's where I started. About 10 years ago, I opened law offices of Amy Demma. A couple of years in between my time at Resolve and my time with my own practice, I did have a very small boutique egg donation agency that I then sold to a larger concern so that I could focus my work exclusively on providing legal counsel. I am one of a group of attorneys in New York who worked for 8 years on getting the Child Parent Security Act passed. I was not a part of the group of the attorneys that drafted the bill. Those were 4 of my very dear colleagues in New York, but I suited up and I joined the ranks, and we quite literally hit the pavement, both with many road trips back and forth to Albany, but also with knocking on our elected representatives' doors, assembly folks and those in the Senate, talking to them about the Child Parent Security Act, talking to them about surrogacy, talking to them about folks like me and Vicki and the folks who are attending this evening who need some assistance to build a family. I am the blessed parent of 25-year-old IVF twins that came to me after a long journey of infertility that had me not only crossing the country back and forth, but also going international to find somebody who could help me to become a parent. So grateful am I for the blessings of my family that I have decided to dedicate my professional life to those who are behind me in this. So the Child Parent Security Act was introduced in 2012 by an assemblywoman named Amy Paulin in Westchester. But before we get to that, Vicki, if it's okay with you, I just thought I'd give a little bit of history on surrogacy in New York, unless you wanted me to start somewhere else.
No, I think, first of all, I think it's so important to hear about your efforts in traveling to Albany and being an activist and getting the law passed. I think that's something that we all need to focus on. So, so definitely tell us more about that. And also, maybe you can tell us it in the context of today's Supreme Court ruling, which is really exciting. And I'm also so glad you mentioned your family. I am gay and I have a partner, and we have 2 children, not through surrogacy, but one through sperm donation, anonymous sperm donor, and the other we adopted. So I also come to having my family through alternative means, which is really what got me into assisted reproduction law and surrogacy. So I've never been more fulfilled than when I was able to change my career path into just doing assisted reproduction law.
Yeah, I join you in that enthusiasm and passion. I started out as an attorney doing litigation, and it's just such a joy to work with law colleagues. And you know, your office and my office has worked on cases, and we represent parties on both sides of an assisted family building effort. Your office might represent the parents, and I might represent the donor, and we do have an ethical obligation to diligently protect the respective interests of our clients, but we do not work adversarially. It is all collaborative between the professionals. I often say to clients, I'm a part of your family building team, and even though you've got attorneys representing different parties in a case, we truly are on the same team, and we truly all are hoping for the same outcome. We want a family to come to be, and that's why we do the work that we do. Yeah, what an exciting day today is. In my office, we call it, when we get a positive pregnancy result, we do the happy baby dance, and we get up and we dance around our desks. And every once in a while, we get to stand on our desks and do the legislation dance. And today was a big dance party in the office. Not that I literally have people in the office. I'm working from my home office these days, but believe me, we were dancing. It's tremendous to see progressive legislation being passed on local levels, and it is even more astounding to see it being done on the federal level. And I encourage everybody who's attending tonight to understand your voice matters. And I'm going to talk about that in the context of the Child Parent Security Act and the 8 years that it took us to lobby that bill, relentlessly lobby that bill. But we were inspired and joined in those 8 years of lobbying for the passage of the Child Parent Security Act by prospective parents, by New Yorkers who didn't have the resources or the emotional or psychological bandwidth or even the practical bandwidth to leave the state to do surrogacy. We were inspired by women in New York who want to be surrogates but weren't able to do that because of the current ban. So it was a collective effort between my legal colleagues, certainly led by the 4 women who sat down and actually drafted the bill, and then a team of representatives from various nonprofits and other interested parties. There was a coalition formed under the umbrella of Family Equality, which is, if I'm recalling correctly, they are the largest nonprofit that provides services to the gay community related to family building in the nation. Family Equality formed this coalition. And I think towards the end, we had 40 members of the coalition, and I'm proud and pleased and delighted and honored that Law Offices of Amy Demma was a member of that coalition. But we came together on behalf of the individuals who now will benefit from this law, as will those who will now be protected by today's Supreme Court ruling. So remember, and I remind myself and I remind my children, your elected officials are there to represent your interests. Pick up a phone, send emails, tweet them daily with what your issues are. If you're not being heard, speak louder. That's how we make results. That's how we get there. All right, so let's talk about surrogacy in New York. I usually start around 1986, but I'm going to actually start about 1976 and just tell you that the wackiest thing, I'm an old school New Yorker. Barney Miller, I grew up in the 70s. I watched Barney Miller. Barney Miller's now being aired again, so it's on my DVR, and I was flipping the channels at 3 o'clock in the morning a couple of weeks ago. And Barney Miller in 1976 ran a story about surrogacy. Certainly I didn't see it, or if I did, I was 11 years old at the time and I didn't know what they were talking about. I've not heard any of our colleagues talking about it, but at the precinct, they actually had to arrest this woman who was engaged in surrogacy. 1976, mind-blowing.
Wow.
Let's speed it up to really cool. For those who are interested in seeing it, they talk about IVF. I guess you can probably find it on YouTube. So just Google Barney Miller surrogacy IVF 1976. 1986, a New Jersey gestational carrier was retained by a couple who needed assistance in carrying. Mary Beth Whitehead was the carrier. Elizabeth and William Stern were the intended parents. They entered into a traditional surrogacy arrangement, meaning there was an insemination done. The eggs of the gestational carrier, Mary Beth Whitehead, were used to create the, to result in a pregnancy. She had a genetic connection to the child. She decided as the pregnancy had gone on for several months that she was not going to relinquish the baby to the Sterns, who were the intended parents as per this agreement that they had entered into. This was a New Jersey case. This was not a New York case. However, those of you who were around then and those of us who were around then, remember it was on the cover of the Daily News every day. It was on the cover of the New York Post every day. The New York legislature paid attention and said, hey, what's going on there? Let's take a look at this. At the time, Andrew Cuomo's dad, Mario Cuomo, was the governor. He impaneled a task force, which is still in existence today and still provides counsel to the folks up in Albany, called the Task Force for Life and Law. And those folks took a look at whether or not, and then Governor Mario Cuomo said to the task force, what should we do about surrogacy in New York? And the task force came back and said, we really don't understand it, and we really don't know what the impact is on the child and on the carrier. So we're going to say no compensated surrogacy in the state of New York. That came out of the task force, and that's where the ban came from. All along until today and going forward. So even though we're talking about the changing landscape in surrogacy in the state of New York, the consistent practice is that of altruistic surrogacy. So even though that task force said to the governor, we've got to ban compensated surrogacy way back in 87, 86 through till today and going forward, when the Child Parent Security Act is effective in February, altruistic non-compensated surrogacy is allowed in New York. So anybody in the audience who is anticipating doing that, despite the fact that we've referenced tonight's webinar as the changing landscape, altruistic surrogacy continuing on. That means no compensation. I do a lot of that work. First of all, because it's the only current surrogacy we can currently do in New York. And secondly, you know, there are folks who are doing surrogacy who do have a sister or a cousin or a best friend who's willing to carry. It's wonderful, but not everybody does. And for the vast majority of folks needing a surrogate in the state of New York, until the Child Parent Security Act is in effect in February, you've had to or would have had to go out of state. And any New York woman wanting to act as a compensated surrogate, she was just not allowed to do so.
It's interesting because I just want to point out that what you were talking about, the Mary Beth Whitehead case, it's really interesting because that was actually what we call a traditional surrogacy. As you said, she's carrying her own egg, her own baby. So when she decided that she wanted to keep that baby, that was her baby, her genetic baby. And though they banned gestational surrogacy for all of these years, even though that was something where a couple would make embryos and those are separate from the surrogate. Those are not genetically related to the surrogate. So it's unfortunate that that case resulted in this ban on gestational surrogacy.
Yep, and that is important. So folks should understand, when we say traditional surrogacy, we're talking about the baby having a genetic connection to the carrier. Her egg was used to result in the pregnancy. Traditional surrogacy is not currently allowed in the state of New York, and traditional surrogacy will not be allowed under the Child Parent Security Act. No can do. And I understand from our law colleagues, Vicki, that that's pretty consistent across the United States. Gestational surrogacy, when the egg provider is either one of the intended parents or an egg donor, the egg provider is not carrying and not in line for parentage. That is gestational surrogacy. So the carrier is only gestating the baby, and that will be allowed, if she is compensated, will be allowed as of February 15th, 2021. So let me tell you about the CPSA. So 2012, it was introduced by the Child Parent Security Act. It was introduced by Assemblywoman Amy Paulin, a woman from Westchester. She's a tremendous legislator and cares an awful lot about children and families, and I'm very, very pleased. She's not my representative. I live out here in Suffolk County, but she's always on my radar, the good work that she's doing. She was joined by Senator Brad Hoylman, who is a senator from the West Village up through Chelsea. He is a dad of children conceived through surrogacy. He and his husband have, I think, 2 children, daughters. That I might not be right about that. They might just have 1. But anyway, from their respective personal experiences with this, they came together and worked really, really hard to get some traction going with the Child Parent Security Act from 2012. But we really didn't make too much progress because we still had that, even though it was resolved, had us up there on lobby days. And from lobby day to lobby day, we were on the phone and sending emails and reaching out on social media. We weren't really making that much progress because still there was this task force report, the Task Force on Life and Law from Governor Mario Cuomo, that said, we don't know the impact on surrogacy. We don't know really what it means for the child. We don't know really what it means for the surrogate, so no can do. Thankfully, in 2017, Governor Andrew Cuomo brought the task force back in and said, let's take another look at this. Let's see if now there's enough data to understand the impact of surrogacy on the child, on the surrogate. And the task force came back and said, thumbs up, let's do this. If we do it as well as it's being done in other states, we think New Yorkers should be allowed to pursue compensated surrogacy. So with that green light, essentially, from this task force, we went to work triple time.
And walk us through. I'm curious, just I didn't mean to interrupt, but I'd like to just, for human interest, when you say you went to work triple time, walk us through maybe one of your trips to Albany and what that was like, because I just think that's really the meat of the matter, visualizing you up in Albany meeting with a legislator.
I'll tell you, I was so moved by realizing my voice as a New Yorker that I started to videotape my feet walking from the train, or my feet sitting on the escalator going down into the tunnel in Penn Station to get on Amtrak to head to Albany, because we were literally walking the walk.
Right.
We were literally hitting the pavement. Right. So you arrive in Albany, and an organization like Resolve, and then later on Family Equality, would have scheduled appointments with legislators across New York. And some legislators entertained us for 15 minutes and were really excited about surrogacy and on board. Some legislators entertained us for 15 minutes and sat there essentially with their hands over their ears. And some folks had great questions, and a 15-minute meeting went 40 minutes. But it's about voicing your perspective on what you want your elected representative to be doing for your community, what you sent them to Albany to do, what work do you expect them to do. And so the first time I went to lobby day, I was intimidated. I didn't understand that I had a voice. I didn't understand how compelling and effective my personal story was and the stories that I carried from my clients. And as the years went on, we did this for 8 years. As the years went on, I became not only more comfortable, but more empowered. And in fact, towards the end, more demanding. I'm paying your salary. I voted you here. This is what I know your constituents need. So let's get this done. So that's what the lobby experience is like. I know Family Equality still has some other legislation they're working on. Resolve certainly has legislation they're working on. I lobbied 6 assisted family building bills on a virtual lobby day on Capitol Hill with 40 other New Yorkers. As a team of 40 New Yorkers, we virtually lobbied some bills just a couple of weeks ago. I encourage every one of you, your stories matter, your voices matter, and gosh darn it, after 8 years, we got it done. We got it done. So 2017, the task force came back and said, let's do this. If we do it right, if we regulate it right, if we balance the interests of the carrier, the parents, and the children, we can do surrogacy and we can do it well in the state of New York. So we went back 2018. We really thought we were going to do it. The bill passed, Child Parent Security Act passed in the Senate, and we got stuck in the Assembly. And we were lobbying until the last second clicked off on the clock. We really thought we were getting there, and the bill failed again in 2018. In the course of that legislative fight, and we were fighting for our constituents, the constituents who needed this legislation. Governor Cuomo said to us at one point in the context of all of this, we're going to get this done. We're going to get this done. So 2019 legislative session kicks in. We're all suited up. We're all ready to go. We're all super excited. Now the coalition under family equality has grown even more. We've got more support, more people going to Albany, super excited, lots of momentum this fall, and then COVID hits. And so we all sort of thought, well, we're not moving forward now. Understandably, the legislature is focused on this crisis. On April 2nd, the bill passed in the Senate and in the Assembly. On April 3rd of this year, I get teary just talking about it. On April 3rd this year, the Child Parent Security Act was signed into law by Governor Cuomo. It is now the law in the state of New York. It does not take effect until February 15th, 2021. So folks should know that. So let's get excited. Let's get your family building in place. Vicky's team, I have worked with them for the last 10 years. I am not only super impressed by them, but I'm inspired by them. They will get you to the starting line. They will take you as far as you can and should go. And they will tell you where you need to sort of halt, because the bill does not become effective until February 15th, 2021. And just a little teeny footnote to that, February 16th, 2021 will be the first day I get to come into my office and practice surrogacy law in the state of New York. It will also be the 26th birthday of my IVF twins. So
oh my God, it's amazing.
It's just all super cool. All right,
well,
so that's
thank you for those kind words about my program. But I also want to personally thank you and all of the lawyers that work so hard on passing this. I would keep up with all of your lobbying efforts, and it's really inspiring. It really is. And I think a lot of us, especially like in the political climate that we're in these days, no matter who you're for, sometimes you think it's just not worth it. You know, it's like, how is my little voice going to make a difference in this crazy world? But you are an example of this really working, of you being able to get there and say what you need to say and work hard. And yes, it took a number of years, but the job got done, and the law is the law now. So just really thank you. So let's get into the act. We talked about the legislative history. So let's just go into a little bit of an overview of the specifics of how couples and individuals will be impacted or affected.
Yep. So the Child Parent Security Act is an incredibly impressive piece of legislation, and my hat is off and will always be to the original attorneys that drafted this bill. It is comprehensive legislation, and last year I started using the reference to it as a model legislation for best practices in assisted family building. So we're going to talk about this, and we are talking about this in the context of surrogacy, but it is a bill that addresses egg donation, sperm donation, embryo donation, parentage. It is a bill that addresses the interests of the surrogate. It's a bill that addresses the interest of the child. It is comprehensive, and I do believe that in those states where surrogacy is allowed simply because there isn't a law banning it. So there are states in which surrogacy is currently legally practiced, not because there's legislation on the books that says, okay, you can practice surrogacy, but because there's no law on the books in those states that says you can't. So in the absence of a ban, surrogacy is being practiced. My expectation is that we are going to start to see more and more of those states bring forward progressive bills codifying the practices of the legal practices of assisted family building, making it law. And I do believe that the Child Parent Security Act is going to be referred to when those states are starting to draft their legislation. It truly is model best practices and comprehensive, addresses all of the issues. We have, for example, and we'll talk about this in a little bit when we talk about the impact that the Child Parent Security Act has on women who want to act as compensated surrogates in New York, something called the Surrogates Bill of Rights. Doesn't exist anywhere else in the country. The brilliance and the genius of the women who sat down to pen this bill said, okay, if we are serious about being a national leader in addressing the interests of the surrogate, which are very, very different than the interests of the parents, in their, in a brilliant moment of many brilliant moments, they came up with something called the Surrogates Bill of Rights. We'll talk about that a little bit more when we get into the specifics, but just so that folks know, all aspects of assisted family building, sperm donation, egg donation, embryo donation, and surrogacy are addressed in the Child Parent Security Act from the perspective of the interests of the intended parents, also the interests of the child, also the interests of the gestational surrogate. And that's what makes it really progressive law and I think an example of best practices.
I think you're so right, and it's so important to talk about best practices, especially in surrogacy. Like I often tell my clients from all around the world that the problem with surrogacy in the U.S. is it's expensive, but that's the only problem with it. Like, here in the U.S., we are really trying to make strides with the law to protect people, both parents and surrogates, and to have the best ethical practices. I know there are other organizations like SEEDS that are really working hard to promote best practices and men having babies. But the New York law really does that. Like, we don't have such a thing in Connecticut. We have good law in Connecticut. We have a Supreme Court case that actually I handled, which allows people to become parents pre-birth and in gestational surrogacy, but it doesn't cover, like the New York law does, what protections you need to have in place for people to make it as ethical as possible for everyone.
I neglected, pardon me and forgive me, but I neglected to thank you and congratulate you on the accomplishments you've made in the Connecticut legislature. I know how long you've fought for it. I know your voice carried it pretty much all the way, and it was huge. And so thank you, Vicki, for, just a couple of miles away from me, changing law for the better there as well. So in fact, if I look out my window, I can wave to you across the Long Island Sound.
No, right? I have a little boat. I could drive it out there and see you.
Well, please do. I'd love that.
We'll talk about that later, but thank you for saying that. But no, but the New York Act really is a model act, and my point was that I think so many states do need this, even Connecticut. Even though we have good law, we could have even better law, and you all in New York have kind of set the stage for that. So it's pretty awesome.
I think so. I agree with you. And I'll tell you, the bill didn't start out as comprehensive as it is right now, but over the course of the 8 years, where we heard concerns from legislators who were not necessarily as excited about the bill as others were, it gave my colleagues the time to say, okay, I hear you. Let's sit down, let's build in some language here that addresses this particular interest that you're concerned about. So it became this very rich piece of legislation because we were able to dialogue even with the opponents. And so that's another lesson to be learned. When you're out there and you're lobbying, you're going to run into seemingly brick walls. And guess what? Don't be deterred. Don't turn away. Take the feedback, hear what the opposition is, and find some way of compromising so that you continue to build that, push that bill forward.
So tell us a little bit about first the parents, and then we'll get into the Surrogates Bill of Rights that you mentioned. But in terms of parents who want to or have to use gestational surrogacy to have their families, what do? First of all, they have to live in New York, right?
One parent needs to be, so if it's a couple, and not not necessarily a married couple. So I want to be very clear about that. You do not need to be a married couple to have protections under the Child Parent Security Act. You can be a single prospective parent who is pursuing parentage or family building on your own. You can be a couple, but not necessarily married, right? So one of you needs to have been a resident of the state of New York for at least 6 months in order for you to have your gestational surrogacy arrangement protected under the Child Parent Security Act. In order for you to access the law, you need to have established or met the residency requirement of being a resident in the state of New York for at least 6 months. Just one party. So if you're a couple, just one of you needs to do that. Interestingly enough, and just as a side note, but important, the carrier too. So any woman in New York who hopes to be a gestational carrier has to also meet that 6-month residency requirement in order for her gestational carrier arrangement to be protected under the Child Parent Security Act, in order for the law to apply to that arrangement to protect her. She can't access the law unless she has met that residency requirement. And that's different, by the way, than what we see in other states where there are a lot of international parents doing surrogacy. I will mention, just as a side note, there may be some changes for the better, changes simplifying things around the Child Parent Security Act. So we are still attending to some things that are not quite right. And I think we're going to take another look at this residency requirement and see if it really does make sense to have a residency requirement of both the parents and the gestational carrier. Maybe just one needs to be a party. I'm not making any promises and I have no crystal ball, but the law as it is today, one parent, 6-month residency, and carrier, 6-month residency. We may see a little change here around that.
So go ahead. Let's say there's a proper match made of a surrogate and the parents. Now, they would enter into a contract. We know that surrogates and parents enter into gestational surrogacy agreements. Are there special provisions that have to go into the contract?
Yes, so the Child Parent Security Act, again, being the comprehensive law that it is, actually does talk about what must be in the gestational carrier agreement in order for the Child Parent Security Act to apply. So when you go for your parentage order, we'll talk about that in just a minute, the first thing the court is going to say is, okay, here are all the requirements of the CPSA. Does your arrangement check all of the boxes? And if it does, then the CPSA will provide the protections it was designed to provide. So I can't imagine anyone pursuing surrogacy without legal counsel, particularly since this is brand new and complex and comprehensive law. Parties really do need to engage an attorney early on in the process to make sure that every step they are taking towards their family building is consistent with what's required under New York law, will be required in, as of February 15th, 2021. So gestational carrier agreements are a good place to start, because what the current ban says, or the ban that's still in place until February 15th, 2021, the ban that the CPSA overturns, it says that gestational carrier agreements, or any agreement entered into between a woman carrying a child purportedly on behalf or supposedly on behalf of someone else, the agreement's not enforceable. It's not recognized in the state of New York. It's not enforceable. So anything that goes wrong, that piece of paper is not worth the paper it's written on. So that's where the vulnerability is in pursuing surrogacy in New York right now. You can't go into court and say, hey, this is what we agreed to, and now someone's changed their mind, and the court today would say, we can't enforce that agreement. It's not recognized in the state of New York. Child Parent Security Act, as of February 15, 2021, will recognize gestational carrier agreements, and that's tremendous, so that the folks can memorialize in these really complex documents, right? A GCA is 40 pages long, 50 pages long, but will memorialize the intentions of the parties, the expectations of the parties, the promises of the parties. And if someone breaches or doesn't fulfill what's memorialized in that agreement, now the New York courts can step in and enforce what was promised before there was a pregnancy underway. That's what's so exciting about the CPSA, amongst many other things.
Oh my God, yeah, no, I think, and so important, why I brought up the contract and what should go into it is so important to have competent counsel in New York to work on such an agreement. I mean, either you or some of your amazing colleagues in New York that understand this law and work on it. As you said, it's complex. And so I think that's a crucial point from hopefully a takeaway from tonight if people are going to pursue this in New York, that they do have competent legal counsel.
What's really interesting is when we were addressing legal counsel in the CPSA, so for the most part, folks who are looking to match, that's a trade term, right? That's a reference that we use when you match with a woman who is willing to carry for you to help you build your family. Those matches typically take place through matching programs like Worldwide Surrogacy. That's how I came to know your work, because the surrogates that you work with are tremendous and people want to match with your surrogates. Under the Child Parent Security Act, well, let me just take a step back. We do have across the country matching programs that are owned by attorneys. And in many states, those attorneys, like in Connecticut, will provide legal services to the clients that match through their matching programs. Under the Child Parent Security Act, the legislation actually separates the services that are being provided to the intended parents. So your matching program will provide one set of services. They recruit the carrier, they send the carrier for screening, get her all ready, and all those things. Legal services under the Child Parent Security Act must be provided by an independent attorney, and that means more than one attorney, because the parents need to have an attorney and the surrogate needs to have an attorney, and both of those attorneys cannot be affiliated with the matching program. So that's also something. So now we started out, my favorite reference to what we do is we're part of a team. Now the team has gotten just a little bit bigger in New York. So you've got your matching program like Worldwide Surrogacy, where Vicki would normally be providing legal services in Connecticut. Under the CPSA, if you've found your surrogate and you're excited about your surrogate and you're thrilled with your surrogate through Worldwide Surrogacy, you're going to need to go outside of Worldwide Surrogacy for your legal counsel, and your carrier is going to need independent counsel that's also outside of the matching program. And just as a side note, by the way, and I think most folks know this, the intended parents are responsible for all legal fees, including the legal fees of the carrier's counsel.
Yeah, that's a really good point, and that really is a good practice. I mean, we're routinely referring to lawyers outside of our program because we work in so many different states. Yeah. So that's and I would welcome the chance to refer the New York surrogacy matters to a New York lawyer who understands this law, because you really want to get it right. You want to get the contract right. You want to set the stage for the parentage action. So can they get a pre-birth order?
We can get a pre-birth order. How exciting is that?
Yeah, that's awesome.
How exciting is that? So that certainly is considered best practices, right? Our objective as attorneys is to protect the respective rights of our clients, whether you're representing the carrier or representing the parents. And frankly, out of the best interest of the child, we want the court recognizing each role of the party in the family building, and there not being some sort of mashing of the roles, right? So we can or will be able to, in February 16, 2021, my children's 26th birthday, that moment when I flick the lights on in my office, I will be able to tell any client that I am working with that we will be able to get them recognized as the parents before the baby is born. That's considered best practices. And from the interest of the surrogate, she wants to make sure the court's not looking to her as a parent. She
Right.
doesn't want any of the obligations that the law imposes upon parents, including child support obligations. So she wants to be sure as early in the pregnancy as possible that all parties recognize her as the carrier and not the parent. We want to be sure that the parents, whether or not they are genetically related to the child. So one of the parents may be a sperm provider, one of the parents may be an egg provider. The parent might not be either an egg provider or a sperm provider. Regardless, if we have done the work well, if we have written a gestational carrier agreement in accordance with New York law, the intended parents will be recognized as the legal parents, and they will be recognized as the legal parents before the child is born. Who else benefits from that? The child. The child will have his parents recognized as parents before he comes into this world. So that's a win-win-win.
Yeah,
right?
At the time of the birth, there's no question.
Yeah, there's no question. The hospital
will you go to court? Will you have to go to court? Will the parents and you and the surrogate all have to go to court, or just the lawyers, or what? Is that known yet?
Yep. Not clear on whether or not the parties, the carrier and the intended parents, will need to make an appearance, but we will be able as attorneys to engage the court and submit a petition as soon as the gestational carrier agreement is signed, actually, or as soon as we know that there's a pregnancy underway. And what does that mean practically speaking? That means if medical decisions need to be made, the parents are recognized as the parents. That means at the time when we're anticipating labor, we let the hospital know all these folks are coming in, and there's a woman there who's got a 9-month fetus that she's ready to deliver, and we can't wait to welcome this baby into the world, but she's not going to be the parent. These other folks are going to be the parent. So things like when the hospitals issue the tag that they put around the baby's ankle, the parents get the matching bracelet. Well, now the parents, the legal parents, will be able to get the matching bracelet. So it works for all parties, and it's huge, and it's tremendous, and it's very, very exciting. Absolutely, New York will be a pre-birth order state, assuming that everything in the arrangement meets the requirements of the law. And that's why competent New York counsel is imperative, because the law is so nuanced. It's so complex. So as long as your gestational carrier agreement reflects a gestational carrier arrangement that is consistent with the requirements of the law, you will be able to get that pre-birth order. Yahoo, that's just the best. That's just the best.
No, it is amazing. Yeah. So tell us a little bit about the Surrogates Bill of Rights. We'll go through a few more slides, and then I'm starting to get a few questions. So we'll have a little section of Q&A at the end. But yeah, we have time. So tell us a little bit about how we protect the surrogates.
Yeah, I'll talk to you about the Surrogate Bill of Rights, and then I just want to give a little bit of info on donors and donor family building and how the CPSA addresses that. And then to all the attendees, anybody at Vicki's office can answer your follow-up questions. If there's something that they can't answer and they want to send over to me, I remain available to you. So, when we say goodnight this evening, it's not the end of our discussion. Feel free to follow up and let us know how we can help you. All right, so the Surrogate Bill of Rights, how exciting is this? First one in the country. That's the way New Yorkers do it. We do it big. So the opposition that we were getting, quite frankly, from uninformed folks, and I did want to mention when I started this conversation about Governor Mario Cuomo and assembling this task force, the task force consisted of progressives and conservatives, medical professionals, members of the clergy. So it really was reflective of a breadth of opinions and thoughts on surrogacy. One of the themes that continued from the folks who were really not comfortable with surrogacy was, were the interests of the carrier being protected? So the parents get to walk away with the baby, but what about the risks that the carrier is facing? And, was she going to be protected under this new law that we were trying to get support for? And so again, through the brilliance of my colleagues that drafted the bill, they came up with a Surrogates Bill of Rights. No one else in the country has one. It says things that you already know, Vicki. It says things that are already, I know, are in practice at worldwide surrogacy, and things that are already offered by the federal government, for example, or federal law, I should say. Not the federal government, federal law, I should say. So things like the carrier having the autonomy, the absolute autonomy to make medical decisions for herself. That's now codified in the Bill of Rights. The ability for the carrier to ultimately make a decision about terminating a pregnancy, not terminating a pregnancy, reducing a pregnancy, subjecting herself to invasive prenatal screenings like amnio. Those things ultimately will be at the sole discretion of the carrier. Now, these are things that are addressed in a gestational carrier agreement. And when your team is doing the wonderful work that they do and bringing together like-minded parties, so you're not going to match a carrier who thinks one thing with intended parents who think something else. You flush that all out with your mental health colleagues and the mental health folks that are on your team, and you bring like-minded people together, and then you memorialize their shared thinking on it in the gestational carrier agreement, not anticipating there being any conflict, but what happens if there is? What happens if someone changes their mind? Surrogate Bill of Rights says that the surrogate ultimately has the sole discretion around medical decisions. We could get sidetracked into a discussion about then, do the parents have the right to sue her for breach of contract because she made a promise in the agreement that she's not fulfilling? That's a side discussion, and we can talk about that. There are protections for the intended parents in that context. But the Surrogate Bill of Rights says what we already know, that women have the sole authority to say what can be done to their body, what can't be done to their body, what they will allow, what they will not allow. So medical decisions, autonomy.
I think like you say, we already know that, but the nice thing about the law is that it's clear.
Yeah.
It's so clear, and I think people will have comfort in that. I mean, it's better to have clarity. And then,
yeah.
as you said, they can make agreements about what their intentions are. And
Yeah.
I always say too, like I, knock on wood, have never had like a situation with a breach of contract in a surrogacy matter.
Right.
And that's because I always go back to the setting and the stage of the surrogacy journey. The screening of the surrogates, the psychological evaluations, the matching. What did the parents want? What does the surrogate want? And if we do that right in the beginning, and we have the right lawyers to help people understand what they're doing, we won't have the issue of a breach of contract. But nevertheless, it's very important that parents understand the rights of the surrogate. And I think that would be a comfort for everyone to go ahead with these types of clear intentions and acknowledgments.
And that really underscores, too, something that is referenced in the Surrogate Bill of Rights, but it underscores the tremendous value of the mental health professional in a surrogacy arrangement. So those issues that you and I in law school we didn't study. We don't bring that skill set and that expertise as lawyers to these arrangements. We rely on and partner with and embrace on the family building team our mental health colleagues who do work with surrogates, so that they get they can flush through and really form an informed position on things like termination or reduction. You do the same with your intended parents. And then we hope, and it sounds like you've reached tremendous success because you're bringing only like-minded folks together. You're bringing folks that have shared points of view on those sorts of things. So to that end, in the Surrogate Bill of Rights, the surrogate is entitled to, at the expense of the intended parents, ongoing mental health support should she choose or want it. And that is something that we see as standard in a lot of gestational carrier agreements, but not codified in the state law that the agreement is written under, and now it is. So mental health support at the carrier's discretion at the expense of the intended parent. Medical insurance, something we all address in surrogacy arrangements. What's different about the Child Parent Security Act is the intended parents are responsible for an insurance policy that will cover the carrier for up to 12 months after she gives birth, after a miscarriage, after there's been a stillborn. So it is an elongated period of time where medical insurance is in place for the carrier, so that if she herself has any complications related to serving or acting as a gestational carrier, there is a safety net of medical insurance which is provided by the intended parents. Life insurance. Yeah.
Just quickly, if she has her own insurance,
Yeah.
would the intended parents still have to pay for that, or would they be able to rely on the fact that she has her own insurance, assuming it would cover a surrogate pregnancy?
Assuming it would cover a surrogate pregnancy, there's no need to purchase another policy. Although, Vicki, I know that it is your counsel, and I think it's great counsel, and I talk to not only folks who I hope will be working with Worldwide Surrogacy, but perhaps folks who've decided to work with a different agency. I love the idea of having backup insurance.
Oh, absolutely. Yeah, absolutely.
It's so important. And I learned about that from you. I learned about that practice from Worldwide Surrogacy, and now I incorporate it into all of my discussions that I have with folks who are anticipating surrogacy. The New York law does not require that the intended parents procure a supplemental policy if there's good coverage in place. The objective is, particularly in the context of the Surrogate's Bill of Rights, thinking about what is in the best interest of the surrogate, just being sure that there is that insurance in place and that it goes out all the way to up to 12 months following either a birth or a stillbirth or a miscarriage.
Yeah, that's an important provision for everyone to know.
Yep. Life insurance. So it is standard practice in gestational carrier arrangements that there is a life insurance policy procured at the expense of the intended parent on behalf of the surrogate, the beneficiaries being typically her family. Sometimes intended parents will purchase a life insurance policy so that they can cover any investments, financial investments they made, if God forbid there was a demise, a death of the surrogate. But generally speaking, the life insurance for the surrogate, for the benefit of her family, in consideration of the risks that one faces during pregnancy and labor and delivery, that's pretty much standard practice. It's rare, if ever, that you read a gestational carrier agreement that there isn't a life insurance provision. Typically, that life insurance is between $250,000 and $500,000 in coverage. Under the Child Parent Security Act, the intended parents will be required to procure a policy that provides $750,000 in benefits to the surrogate's family should she pass away during the surrogacy.
That seems reasonable, and people can get term insurance that doesn't cost so much. So, I mean, $750,000 sounds like a lot, but to be able to get term insurance wouldn't, I think, affect the cost too much.
No, it's a couple $100.
Yeah.
Yeah. So you know, the Child Parent Security Act is reasonable too. So it's comprehensive, it's best practices, it protects the interest of all parties, the surrogate, the parents, and the child, but it's also reasonable. And those things that don't seem like they're making sense or think, you know, that they need a little bit tidying up, we're going to address that in the next legislative session. So let me just talk a little bit about agencies and a little bit about donors, and then we can get to the Q&A. So agencies, in order for a matching program, an egg donor, a gamete donor program, so where folks would go to procure sperm or eggs or embryos or a carrier. So, you know, procure a carrier, match with a carrier, but any service that is providing matching services will be regulated by the New York State Department of Health. That's new to the field of surrogacy as well. So the agency will be licensed in the state of New York, and there will be regulations imposed upon them. They are not designed, or that is not designed to be prohibitive. we want New Yorkers having options for agencies. We don't want to deter or discourage agencies from doing business in the state of New York. We simply want to know who you are, so you've got to be registered. We want you to be licensed by the Department of Health, and the Department of Health will establish some regulations around your practices. Those regulations have not been fleshed out. I'm happy to say that I'm a part of the team that's working on those regulations. So that's just another piece for you all to know. So the New Yorkers out there, you'll engage an agency that's doing business in New York, but in order for you to be protected under the Child Parent Security Act, in order for you to access this fantastic law, the matching program that you're working with will also need to satisfy the requirements of the Child Parent Security Act. Carriers, is there anybody listening out there that is a New York woman intending to be a carrier, you will only be able to do so if you are registered with an agency that meets the criteria established by the New York Department of Health. So that's just a little top line about agencies. There's more to talk about. We can do that either at another time, or I can answer questions offline. With respect to sperm donors, egg donors, embryo donors, a really cool thing about the CPSA is that a husband and wife who are now dissolving their relationship, or two partners who are dissolving their relationship, if they came together to create embryos with the intent to parent, currently one party, now they're splitting ways, one party can't donate the embryos to the other party because the law currently says you made those embryos with the intent to parent. If a child results from an embryo transfer of those embryos, then you who came forward and said you intended to parent will be recognized as a parent and will be held to child support obligations. So I get lots and lots of calls from divorcing women who say, my husband's willing to give me the embryos we have left over because I really want to continue on with my family building, but I want to waive his obligation to child support. We can't do that currently in New York. A prospective parent cannot waive the child support obligation imposed under current New York law. That will no longer be the case under the Child Parent Security Act. So a party who created the embryos with the intent to parent can in fact donate those embryos to the other party with whom he or she made those embryos and be relieved of child support obligations, which means a whole lot of frozen embryos that weren't able to be used are going to be able to be used. So that's super exciting.
That's an amazing, wonderful provision of this law. I think that will solve so every state. That should be a federal law.
Oh well,
every
give me a couple of years, Vicki.
Yeah. Every state should have that. I mean, that is such a mess for so many people. All those people who have had cancer and they can't use their embryos. It's ridiculous. I'm so glad that should definitely be a model for every state in the country.
It's really sad when there are women who lose the opportunity to have a genetic connection to their children because they made these embryos with somebody that they are dissolving a relationship, a partnership, a marriage with, whatever it is that they came together. So so that's super cool. Egg donors, it also of interest, there will be a voluntary registry for egg donors, embryo donors, sperm donors, and surrogates, not mandatory, but voluntary. The state would like to keep track of who is acting as donors and the children that are coming from the donation. That's not mandatory, it's voluntary. And what else do I want to say about donor family building? So if, sperm donation. So right now under New York law, sperm donation needs to be facilitated by, all gamete donation needs to be facilitated by a medical professional in order for the sperm or egg provider to be recognized as a donor and not a parent. You need to have a medical professional facilitate the donation. It's a given in egg donation. Nobody's doing egg donation at home. Nobody's doing a retrieval at home. But we do have folks who are hoping or wanting, for very really valid reasons, intimacy, financial, not wanting to engage a physician for sperm donation. Historically, if you didn't work with a clinic or a medical professional in your insemination and you did an at-home insemination, historically, many of those would-be donors being held to be fathers and having child support obligations. now you will be able to do your at-home insemination. So that's really cool too. So I think we probably should get to some Q&A.
Yeah.
What do you?
I just want to say that is really cool.
Yeah.
Even we have donor laws in Connecticut that say that you have to use a medical clinic. I mean, that's a statute that if you don't, you won't be protected from parental obligations. It's so good that we've been able to, in New York, to carve out that ability for people to do that. It makes sense. So it's great. It's a great law, and I'm so glad we're talking about it. We'll have more webinars, everyone, on this, because we can actually break it down into parts. We can talk about what will go into the contract, what people need to know when their baby's born, things like that. So.
And donor family building too.
Yeah.
Yeah.
So I have a question. So it sounds like surrogacy is only acceptable in New York if both parties are residents of New York, correct? So IP in New Jersey could not have a surrogate in New York and have their contract be enforceable. That would be true.
So a couple of things that I want to correct on. Great question. Thank you so much. So under the current law, only one of the parents, so if you're a couple, only one needs to be a resident of New York for 6 months, and the carrier needs to be a resident of New York for 6 months. But if you are New Jersey residents, the gestational carrier, it will be able to be a carrier in New York, but you can access New Jersey law. So just know that. So again, that's why you really want to speak to somebody who understands the New York law, so you understand where it's enforceable. And if you're not meeting the requirements, you won't have the protection of the CPSA. So the CPSA will not be referenced in your gestational carrier agreement. But in this scenario that was just presented to me, New Jersey law would be, and it's really good law. The New Jersey Gestational Carrier Act, I think that's what it's called, the New Jersey Gestational Carrier Act. Pardon me if I'm not referencing it correctly. I didn't work on that legislation. My New Jersey colleagues did. But there you go. So you probably would be able to pursue that under New Jersey law. You just would not, without the residency requirement today, as the law is today. We're going to try to address that residency. We may tweak it a little bit if we can get the legislature to agree to that. But today, at least one of the parents needs to be a resident for 6 months.
Yeah, a lot of questions about residency, and sometimes people are like not really happy to be paying lawyers, but you and I can have our love fest. Like, it's important to have competent legal counsel. This is a complex area. A lot of law areas are complex, but you're having a baby. This is a complex area of the way to have a baby. You want to be the legal parents of your baby. So it's like, that saying, penny wise, pound foolish. You have to be able to see that you need to have a good team, whether it's a good clinic, a reputable matching agency, a reputable, knowledgeable lawyer. There's a team that has to be put in place to have a baby through surrogacy. So
and where the lawyer is licensed matters.
Yep.
And the area in which the lawyer practices matters. So often I'll get calls and they'll say, well, my cousin does wills and trusts, and well, my sister does real estate. And, I'd never take on a client for any matter outside of my area expertise, and there's significant risk for anybody that does. And I'll add another layer of concern that you have when you're not following what Vicki is suggesting as best practices. I certainly endorse that. This is emerging and new law for the courts in New York. And so if you don't have competent counsel and you've got a judge who doesn't really get it, you're going to find yourself in just such a mess. So work with New York counsel who does assisted reproductive technology, so that if we need to help the court along in getting you to where you need to be, legally speaking, we have credibility as art attorneys to do so. So it's not your cousin, the real estate lawyer, who's coming in asking for a parentage order in your gestational carrier arrangement.
No, I think you're right. I think in situations like this where there's new law and new procedure, a lot of times it's the lawyers who, with all due respect to judges, but it's a lot of times the lawyers who are actually educating or informing the judges about, this new law and what it's going to take to process the pleadings and the proceedings. So here's another question. Where can we get the CPSA? Where can people get a copy of it so they can look at it?
Google it. Just Google it. Child Parent Security Act, New York. It'll come up. If you can't find it, be in touch with me or Vicki. Anybody at our office will get it right to you. But just Google it. Child Parent Security Act, New York.
Here's another one, if I can understand it. Does the Child Parent Security Act only matter if you're doing a gestational surrogacy if the surrogate you match with lives in New York? What if you live in New York and they live in Connecticut? Are both still protected under the Act?
Well, you would probably, if she's a resident of Connecticut and going to deliver in Connecticut, that's where a Connecticut lawyer, that's where someone like Vicki is going to petition the Connecticut court for a parentage order. So you're going to access Connecticut court in that regard.
Okay, and now, here we have a friend of ours, Cindy Wasser, who's joined us. Hi, Cindy.
Hey, Cindy.
Hi, Amy and Vicki. Does the legislation deal with recognition of parental rights for births abroad? Do my New York clients having a baby in Canada still need a court order from Ontario, or could they simply use a birth certificate? We can do a court order or administrative registration.
Yeah, so the Child Parent Security Act does not address international intended parents, surrogacies that are happening abroad. We have not addressed that.
Okay. Yeah.
But we can talk more about that, Cindy. Give me a call tomorrow.
Yeah. Can it be written in the contract to give the intended parent the right to decide regarding termination, amnio, reduction, etc., despite that law?
Not the right to decide. So the right to make that decision belongs to the carrier. What can be reflected in the agreement is a representation that she's making to the intended parents of her intention if you had a diagnosis of a profound birth defect, for example, or whatever would be the compelling reason to be considering termination. The carrier will make a representation in the gestational carrier agreement as to what her intentions are in that context. Presumably, those intentions are going to jive with what the parents' intentions are, because that's something you flesh out at the matching phase to make sure you're bringing parties of like minds and shared minds together on this. Having said that, there is nothing that we could draft into any gestational carrier agreement that could compel the carrier to terminate or not terminate or reduce or have an invasive procedure. Your only remedy as the parent is, hey, you said you were going to do this. We relied on that. We moved forward in that reliance. Now you've changed your mind. We're suffering because you've changed your mind. And the law does allow for remedies for you, but nothing will compel, no court order anywhere in the country will compel a carrier to terminate simply because she said she would in a gestational carrier agreement.
Yeah, I think the New York law just makes it clear, very clear, but we all know that the federal law provides that a woman has a right to privacy to make decisions for herself. So I always go back to the screening and the matching. People have to be on the same page. We have women who want to become surrogates who say, I will terminate, but not for Down syndrome. So we have to have parents that are A-okay with that, 100%. Everything's got to be transparent in the making of the match. And if it is, there won't be these problems of people changing their minds or wanting one thing and somebody wants another.
And again, that goes back to the tremendous value of the mental health professional on this team, because she knows how to ask those questions and really get, peel back the layers and really get to a core feeling about these very unpleasant things. None of us want to have to think about this, but as attorneys, we've got to protect our clients from worst case scenarios. And it's from that recommendation from the mental health evaluator, we then, or you then, Worldwide Surrogacy then proceeds and makes matches of like-minded people.
Here's a good one. Hello. Could the
Hello.
search and match process for a GC, a surrogate in New York, start before February 15th, 2021?
Well, so I'm not exactly sure what start means. You will not, should not. You will be in violation of current New York law, and that does carry financial penalty. You will be in violation of New York law if you formally engage with an agency to match with a carrier. You can sign up with an agency now and say, look, I'm going to do this in February after the CPSA is passed, and you can start looking at profiles, and you can start, you know, maybe she's being screened, but you cannot formally engage any party in anticipation of compensated gestational surrogacy until February 16th or February 15th, 1991. 1991, forgive me, 2021.
Let's see. Well, maybe we have time for, I'm just trying to look for one that will. Carissa, thank you, says, thank you for this great info. Could you go over embryo disposition with a couple under CPSA?
Yeah, so the embryo disposition was not, the embryo disposition options that are available to parents to parties who create embryos and have them in storage was not changed under the CPSA. So quickly, any party who owns the property of embryos, and embryos are property with a potential for life, but they are property. Anybody who has ownership over this property known as embryos can, is not encumbered by the law, is allowed to destroy the embryos, keep them frozen indefinitely. If you're comfortable paying storage fees for years, my husband and I paid storage fees for close to 10 years because we didn't know what we wanted to do with our embryos. We were allowed to continue to do that. We had no obligation to make a decision about them. So you can keep it frozen indefinitely. You can have them destroyed. You can donate them for medical research. Most parties tend to donate them to their clinic for education, teaching purposes, with an understanding that there'll be no potential of it resulting in procreation or a pregnancy. Or you can donate them to a third party for family building. The CPSA did not take away any of those disposition options. The only thing the CPSA does with respect to embryo donation now says that one party who expressed an intent to parent any child that might result from that embryo to donate those embryos and relieve him or herself of child support obligations. So if there's anybody out there who's at a clinic, you need to go back and you need to take a look at your consent forms, and your consent forms most likely don't reflect what I just expressed. And so you'll want to talk to somebody like Vicki or somebody like me or my other New York colleagues to be sure that the consent form reflects the Child Parent Security Act and its allowance of donation and relief of child support obligations. But the disposition options still remain. All disposition options that were allowed, that are allowed today, will remain available to New Yorkers under the Child Parent Security Act.
Well, that's about all the time we have. Thank you so much, Attorney Demma. I really appreciate you being here. I very much enjoyed doing this with you. Is there anything that you want to say to close out for us?
Other than be sure that you're seeking the right counsel. Not having the right counsel, making a mistake with surrogacy, not only has significant financial impact, and we're talking about a lot of money here. You know, Vicki and I are very familiar with receiving checks from grandma and checks from the uncle, and you know, people they have GoFundMes and second mortgages, and it's heartbreaking. And so we're very respectful of the financial risk here. Please don't take your own financial risk without seeking proper counsel. And that's not even speaking, so, you know, we can speak about money and maybe it's uncomfortable to do so, or maybe it isn't, but we have to acknowledge the big ticket items here. We've got to acknowledge the investment here. But how about your time and your emotions and the impact on that? If you choose to cut corners, take a short cut, and then you find out that you're in a legal mess and you're no longer on track to family building, you're on track as a litigant in a lawsuit, and that really, really stinks. I don't want to see you make those mistakes. So early on, engage proper counsel, licensed appropriately in the state where your carrier lives and is going to deliver, and have them provide counsel throughout your embryo creation, your surrogacy journey, your parentage. Oh, one of the things I didn't mention is wills. You've got to have a will in place. You've got to have a guardianship. Your carrier, God forbid something happens to your parents, the carrier does not want to go home with the baby. She wants to go home and be done with you all. And so there needs to be somebody in your family or in your social circles who's going to step in as a parent if something happens to you. So again, proper legal counsel with respect to a will and other such documents as well. That's my counsel to all of you. I'm thrilled always to work with you, Vicki. You're a dear friend, a well-respected colleague, and I think the world of your team.
Well, to continue the love fest, I think you're amazing. I do really respect your work and all that you did to help get this law passed, you and your colleagues. And so Amy and I are available to you as a resource. And you can see on this slide our phone numbers if you'd like to contact Attorney Amy Demma for more counsel. Her number is 516-662-7532. And we will plan some more of these webinars. We'll try to break it down and see if we can help out people some more to understand this new law and surrogacy in general. So stay tuned. And thank you very much, everyone, for joining. And keep in touch.
Have a good night, everybody.
Good night. Have a good night. All right. Stop. How do I end it?